Thank you, folks. I'm just told I have no sound. So there we go. I appreciate that. So what I'll do is I'll just start over from the top. Just welcome everyone to Ask the Lawyer Live. This is our weekly show where I answer your questions. Today is Wednesday, so it is the day that I talk about employment matters. And today's topic, let's take a look. So today's topic is going to be what to do when you're written up at work. I'll walk you through what it means, why employers use this. It's part of something called progressive discipline, which I will talk about. And most importantly, I'll talk about how you can protect your job in the event that you are wrongfully terminated after getting a written warning. Let's dive in. All right. So let's start with the concept of progressive discipline. Here we go. That's the right slide. The idea is that employers will try to correct performance or behavioral problems from their point of view through a series of increasingly serious warnings. So the idea is that with progressive discipline, an employer, if they're unhappy with your behavior or whatever, performance, they will start with a verbal warning. Then they will move on to a written warning. Then if the behavior doesn't change, they will move to a suspension where you're suspended without pay. And then finally, if the behavior from their point of view continues, they will terminate you. And at that point, if an employer has followed properly the steps of progressive discipline, they're allowed to terminate an employee for just cause, which means they don't have to pay severance. So now employers, they're not legally required to follow this process, but most do, especially larger employers, because it creates a paper trail that allows them to show that they gave you a chance to improve your performance, and it can help defend themselves when they want to dismiss you without paying any type of termination pay. Now, most employers, like it's hard to do this right, but if employers are well organized, that they can create such a paper trail that makes it very hard for an employee to fight back if they're disciplined after going through this series of progressive discipline. Now, getting a written warning does not mean that it is a serious moment in your employment, but it does not mean that you are being fired right at that time. It can be later used to justify firing you for a cause, meaning that they don't have to pay termination pay. And here's the key. So if you don't respond to it, it can be treated as though you agree with it. That's probably the first point you want to take away from this, is that if you receive a written warning and you don't respond to it, it can be taken that you just agreed with the warning, and that can come back to haunt you later on. So what should you do? First, you don't want to ignore a written warning. Now, usually you will have received a verbal warning around the same type of issues earlier, but if you've now gotten a written warning, you don't want to ignore it. You want to review it carefully for mistakes, any exaggerations or missing context of what really happened. And then you really should respond in writing. That can be whatever way that you communicate with your employer. Sometimes that's by text, sometimes by email. Whatever way you do it, or even written it out on old-fashioned paper, whatever way you do it, it's very important that you keep a copy of what you respond with to the employer. Because if you're later terminated and you may lose access to, for example, to your email, or if you're using a work phone, you may lose access to that. So you won't have that proof later on unless we can somehow get it from the employer. Now, when you respond in writing, it is extremely important to be respectful. Even if you feel like you're being disrespected, you have to respond in a respectful manner. Set out your version of the events and indicate any areas that you think need to be corrected or that are lacking in the context or important information that's missing. Now, depending on the level of detail they've given you in the write-up, you will want to ask for clarification on exactly what are they looking for from you going forward. What do you need to do? If you need help, ask for training or coaching, and make sure that you document that you've asked for training, coaching, help, or clarification on what exactly they want to see from you going forward to prevent future warnings. And finally, you should consider getting legal advice. Once you get a written warning like this, it is often a sign that the employer is, in many cases, this when employers start this process, they usually have an intention to terminate an employee. Not always, but this can be an intention. So they're building up a case to be able to terminate you. This can often be accompanied by like if they're really just trying to set you up, then some of the complaints or the reasons for the warning may not be valid. So it's important to talk to a lawyer before you respond in kind of an unprofessional way or get aggressive back with the employer. You will, if you think you're being set up, it's more important that you act in a very calm, collected way. And speaking with a lawyer and reviewing the situation can help you figure out the best ways you can respond to in what you think is an unjust write-up. Okay. Now, mistakes you want to avoid. The big one is getting emotional and aggressive. Employment is very much like I often say, I work in this area of law, but it's very much like working in family law, divorces. Both are very emotionally charged. So employment situations can be very emotionally charged. And if you act out in a way where you say things in an aggressive, emotional way, that will come back to haunt you. It can hurt your credibility. It's critical that you, even if you're being acted towards in an unreasonable and emotional way, you should not respond that way, especially in writing, because that is what the proof, like writing will be proof of what actually happened, whereas people can dispute what was said verbally if it's not recorded. Now, another mistake I see is people just refuse to sign the written, like they just refuse to sign it when they get a written notice or a written warning. Don't do that. You can at least sign it saying received but not agreed to. Like that's perfectly fine to say something like that, but you shouldn't just refuse to sign it. I guess what people are worried about is if they sign it, it means they agree with what's written on it. So you can just write on it, signed, received, but not agreed to. Like that's something you can do, but only do that if you really don't agree with it. Or if you don't agree with all parts of it, you could write sign, but don't agree with all aspects of this. Something like that. Another mistake is talking to coworkers about the warning. Probably shouldn't do that. That is a common thing that people want to do, but it creates more workplace drama and it can backfire because some of these employees may be, they may be part of the problem and going back and telling management that you're saying this, you're saying that. So a lot of it can backfire on you. It's just better not to discuss this with coworkers if at all possible. The other problem would be waiting too long to act. Timing matters, and the sooner, if you really disagree with what was written in there, the time to say that is immediately, not like 6 months down the road when they're terminating you and you're saying, well, the reasons they gave before were incorrect. Like that won't serve you well. The courts always want people to act quickly on their rights. So it's important when you get a written warning to act immediately, to confirm with the employer if you disagree with any parts of it, and also to get their help on what is needed for you to improve and to have that all documented. Very important. All right. So why does this matter? The issue here is for wrongful dismissal. That's when people are fired from their job without giving proper notice or compensation. The way being written up works into this is if you're fired down the line, the employer can often point back that you were given a written warning and that you didn't improve your performance. In fact, sometimes the employers will have multiple written warnings and point back to that as reasons why it's now justified to fire you without paying you any compensation. But if you responded at the time to these written warnings and asked for help and how to improve and clarified points of it, you've kind of built in your own case to show that your employer is really acting unfairly. Because believe it or not, some employers do use this as just they decide they want to get rid of somebody, so they manufacture these. They just look for infractions and problems and then just start writing you up. That is a common thing that happens, but it's easy to show that if you also along the way asked for help and improvements along the way and had that documented. It's much easier for us to show that the employer was just manufacturing these fake reasons to try to terminate you. Okay. And if you responded along the way and asked for help and no help was given, like that's really strengthens your case in us arguing for severance pay. So the key takeaways here are a written warning is a serious thing. So you should not ignore it. You want to respond carefully and respectfully is the most important thing to maintain your credibility. You definitely want to keep records of your efforts to improve and to what extent the employer has helped you. And definitely get legal advice if you think that you're being targeted or that this is all being manufactured. And with that, I will move on to questions. So if you have any questions about a termination situation or being written up, again, it usually follows a process of going from a verbal warning to a written warning to suspension. That is the classic way for progressive discipline to happen within a workplace, but not all employers will follow it that way. Okay, so let's dive into our questions here. Happy to answer any questions if people have them, and I'll just give you a second to type those in. While people are typing, one of the things that I often see with we see these all the times where employers do, like most people that hire us, it's because they've been fired for cause and not given any compensation whatsoever. Most times, like probably the majority of people who get terminated, the employer does offer some amount of termination pay. It may not be like the ideal amount that you're owed, but it's enough that it deters you from getting a lawyer, because if you get a lawyer, you got to pay the lawyer. So like there has to be enough more above what they're currently offering to make it worthwhile. A lot of people hire us because they've been terminated with no payment whatsoever. Generally speaking, it is very hard for an employer to justify that. Now, one of the ways they can is by having well-documented progressive discipline, but even then, they really better have their ducks in a row. It's difficult to justify firing someone without paying them unless they've done some egregious thing. So like it has to be almost to the level of an assault where there's putting other people at danger, that type of level, or theft. Those are the kind of level of things where people can be fired. Everything below that, it is very contextual, and it will depend a lot upon whether, like, a lot of it will look at whether you had warnings and whether you warned the employee and gave them time to improve. So the more that an employer can show that they gave warnings and offered assistance, and in spite of all that, you continue to have problems, those are the cases where a court's going to uphold them terminating you without severance. But if they haven't done that process, or if the process does appear to be kind of a sham, then courts will not hesitate to order them to have to pay you severance. A common trend that we see is like if, especially in sales. So, for example, in sales, when they want to get rid of a salesperson and don't want to have to pay them any severance, they will just create maybe unrealistic targets and then apply it and say, oh, you're not meeting these targets. Like we have a case right now. It's not actually sales, but it was a similar thing where a driver had to meet certain targets, and basically it was impossible for anyone to meet those targets. This was all a sham. So in those kind of cases, just because they've manufactured warnings and things, it doesn't mean that they're always going to be legitimate. You have to treat them serious, but they're not always going to be legitimate, because sometimes it's just easy to show that this was all a sham. These weren't realistic targets. No one could meet these targets. They were basically setting the person up to fail. If you can prove that an employer is actually engaged in that kind of behavior, that's when you can get into aggravated and sometimes punitive damages, which are paid above and beyond what you would normally get for just regular severance and termination pay. So that's important to keep in mind. The main areas where we typically will see people getting extra money in an employment case, the main ones that we do are usually related to disability, because that's really our specialty. So for us, most cases where we're getting people termination pay, it's related to people who've been, aggravated and punitive damages and human rights damages. It's usually cases where people are fired related to an illness or disability. Those are the most common cases that we do at our firm because of our focus on disability and employment. So if you ever know anyone who's been fired, like the typical way you see it is people fired while just coming back off of a sick leave, or being fired once they give notice they need time off for sickness, or around when they find out they have an illness. Sometimes people are mysteriously fired at that point. You do have to prove that there's a link between the illness, sickness, and disability and the firing to show that it's discrimination. But if you can, there are extra damages you get. So there's damages for, in those kind of situations, you can get damages for wrongful, you get the wrongful termination damages. You can also get damages for discrimination for against disability. And there's also what are called aggravated and punitive damages, which are paid. The aggravated damages are paid. They kind of overlap slightly with damages for human rights violations, but they are to compensate you for the kind of humiliation and the mental stress that you would get put through from being fired in such a way. The punitive damages are simply to punish the employer if they have really acted in an unscrupulous way. So like punitive damages could be awarded if you could show that they completely manufactured, like they decided ahead of time they want to terminate you and set out to manufacture these written verbal warnings and all this, that they just manufactured them out of nowhere. They weren't legitimate. That would get an employer in hot water and could definitely result in punitive damages. All right. Now, one of the things I'm looking at for tomorrow is possibly doing an update on the Canada Disability Benefit. I'm kind of waiting. I've been waiting, hoping that there's going to be an update from the government, but I haven't seen one yet. No, I don't see anything yet. So it's possible I'll decide tomorrow, but it's possible I may put it off another week, just waiting for an update to come out of the government. Right now, we don't have really any new information from when I spoke about it last time. So if you wanted to see it, you could go back and look. Let me go check where it was. I've now numbered all of our, whoops. I'm hearing myself on the screen here. There we go. Get that out of there. So yeah, it would be, if you go to our website, you can go back to previous episodes. The episode where I talked about the Canada Disability Benefit was episode, where is it? It was an early one. Here it is, episode 5. Looks like I did it late at night and the lighting was bad, so it looks like David After Dark or some kind of crazy thing. So yeah, episode 5 is when it was about a month ago that I talked about the benefit. So there hasn't been any updates. What I'm waiting on is an update on how the application process is going to work. So as soon as I see that, I'll do the update. But I know people are really on pins and needles waiting to see how this thing is going to unfold. But I'll do a more in-depth look. And if there's enough more to talk about, then I'll maybe give a minor update tomorrow. But I'm definitely going to want to give a big update once we get a full information. All right. Did anyone have any questions about any other topics? If not, I'm just going to call it a day, and I will see you guys back here tomorrow. Tomorrow will be our live call-in show, so if anyone wants to call in to ask questions live on the air, you can feel free to do that. We'll have the number available that you can phone in on, and I'll answer your questions. So I guess that's all for now. We'll see you guys back here tomorrow, and I do wish you all the best. Take care.